now. Is there anything in the constitutional amendment that you pushed through a couple of years ago that could come close to addressing this issue?
No, actually, we specifically exempted the lakefront property owners from the constitutional amendment because we felt protecting inland water rights and private water rights, groundwater rights was critical. We didn't want to subject that to elevating this debate to the constitutional question.
Is it possible that that the letters asking for lease payments is just, you know, a couple of that have fallen through the cracks and misunderstanding? I mean, how many of these letters, can you tell us? I mean, is this just a couple?
There are letters that go out, and they're followed up 2 months later by another letter, a Dunning letter, indicating that more formal legal action will be taken. So they're not just misplaced letters that somehow went out. Again, there's a follow-up action on it. Again, claiming action to be sent down to Columbus. It should, again, the lease not be paid within 30 days.
Can you give us some idea of how many of these letters you've discovered?
No, I can't. I know that they're out there. People tell me about them. My understanding from ODNR is they send them out to every leaseholder that is out there. But that's my understanding from actually ODNR themselves, that they recognize they do send these out because according to ODNR, they have rules, and their rules indicate that they must send out these letters. They indicated 2 months after the governor's statement back in September 2007 that to all leaseholders that they recognize the fact that the governor made this decision not to charge this, and they said that they have a problem with their rules and need to change the rules. That was over 3 years ago. They have not changed the rules. They're either dragging their feet. How long does it take to change rules for something the governor told them to do, or just implement what the governor told them to do? I mean, that's pretty simple to implement that.
So the letters have gone out throughout the litigation. It never stops anymore.
That is correct.
Why are you raising the issue now instead of...
We're raising the issue now with the statements that are going on in the Supreme Court, because again, in the Supreme Court, the ODNR is now coming back after the governor has indicated that they've dropped out of the suit a couple of years ago, just within the last week or so. ODNR appears to be coming back. We don't know whether it's really ODNR or the governor's wishes, so it's kind of a combination of the two. One's an ongoing problem, one is one year's a brand new problem.
When that's a question the court's going to decide, they've already accepted arguments on that, right?
Well,
as to the right of the Attorney General and ODNR.
I'm not an attorney.
That's the first issue.
Interestingly enough, after the appeals were filed, acting as chief, Justice Pfeiffer sent out a notification to the parties asking them to brief 2 questions. And the first question was, does the Attorney General have any basis for being here? And the second question is, if the Attorney General has a basis for being here, is the record complete from the appellate court to address issue 1, seeing that the appellate court struck all the Attorney General's filings in the Court of Appeals as not having standing? So that issue is being briefed. The court itself hasn't ruled on if they're taking anything beyond looking at that question at this point.
They haven't even accepted the case.
I don't believe they have. I believe they're still looking at these 2 questions.
And you would urge them not to.
Take the case?
Right.
Other than they take the case in the firm. I think the issue needs to be...
But if they don't take the case, let the district prove stands.
Well, I mean, that would be satisfactory, but I do think there will be ODNR or others will then try to limit this case even though it wasn't certified class action. And so I do have some residual concerns about, you know, the old, it's only one Court of Appeals argument.
You said that ODNR appears to be back. Are they actually named as a plaintiff or an appellant?
They've actually filed.
What happened was the governor ODNR filed a cross appeal in this case back in, I think, October, which is hard to understand because if you weren't a party of the Court of Appeals, you don't get to come on the Supreme Court and start raising new issues and cross appeal and stuff. You're not there. So that's the question I still haven't got a satisfactory answer from Kim Marcus on. But they have also now, ODNR, the governor, has filed briefs on the issue of the Attorney General's right to be there and has made themselves, attempted to make themselves parties in the Supreme Court, which we think is contrary to the position they took in the lower court.
But they weren't in Cordray's file. ODNR was not in.
No, they have their own lawyer. They have their own lawyer. ODNR and the government have their own lawyer.
Have they filed any papers indicating that they are arguing that these leases, that the homeowners do owe the money on the leases?
Not in the filings to date, but that won't happen. That's the answer to that question. That won't happen until the Supreme Court rules on this preliminary question.
The whole idea